motion the court to strike what is on docket 841. There was an error in the initial motion we filed this afternoon, and we filed a amended corrected motion at docket number 842. And we would ask to strike 841 and remove it from the docket.
Give me just a second.
Yes, Your Honor.
Is there any objection to that?
Good afternoon, Your Honor. Christina Stifler, Alan Mizrahi, and Stephen Siegel on behalf of the state. I have reviewed the defense motion. The state does not oppose.
No, I mean striking that.
Oh, no, ma'am.
Okay,
I've reviewed both motions.
okay.
I don't oppose them striking it.
So I'm going to direct the clerk to strike the document 841 from docket line 18.
Yes, Your Honor.
Give me a moment. Let me ask, so about the argument that is contained on page 2, 3, 4, related to, this is my question. So obviously, what is argued by the defense is that this is a law enforcement created issue. And while I do know that discovery is somewhat limited when there is a quote unquote pending / ongoing investigation, through the discovery process, how much access did the defense have to this information? Because I have a vague recollection that this came up at some point in time during the pendency of this litigation.
Thank you, Your Honor. Kirsten Nelson on behalf of Ms. Gardner. Candidly, Your Honor, we had some understanding that there was an allegation against Mr. Fernandez. I believe it was as early as June 2025. However, it was our understanding as of June 2025 that these were unsubstantiated allegations, and we did not my understanding based on representations of co-counsel, that we did not have any reason to believe that they were being followed up upon by law enforcement at that time, which makes sense because why would they tell the defense that there's an ongoing investigation? So while this one portion of the allegations, I understand there are two separate counts. So we knew part of the story, not the full story, nor did we understand that there were forthcoming charges.
Okay. So, and I'm just on this point, okay? From the defense perspective, I know the word investigate can mean many different things. To marshal what you believe you would need in order to defend your client, what are we talking about?
I appreciate the court's question. Earnestly, Your Honor, I'm not sure I'm in a position to answer that since the information is still forthcoming. We don't actually know the charges yet. As I understand from the state, the charging document has not been made public. We do not have access to it. We would need a little bit of time in order to put a more precise point on that for the court. I understand that's not a very satisfying answer. We could request, Your Honor, that we come back for a status perhaps next week or at the court's pleasure, where we could give the court a more specific answer as to what specifically we would want to investigate in order to fully perform our duties and obligations to our client, both under the Constitution as well as the Florida Rules of Ethics.
All right, I appreciate that. Let me turn to the state of Florida. You said you don't have any objection to the motion. In order for me to gauge whether this is something that this court should entertain or not, I need to know what the position is of the state of Florida related to its, are we going to be litigating every day that they say they want this and you're not going to give it over? Or, I mean, how is that playing out in the state's perspective? The access to documents, and they say that they need to investigate it and they don't have anything to like really go on at this point in time based on the timing of this information to them.
Yes, Your Honor. The state has tried in its best efforts in good faith to make information aware to defense, as is our discovery obligation that could potentially impact them in this trial while still maintaining the privacy of the victims in these cases and the integrity of the investigation, which is why we let defense counsel know about this and have taken steps to make sure that we have been in a position where we could effectuate the arrest and inform them ahead of trial so that they can make whatever decisions they needed to make and request whatever they needed to make. Our Special Victims Unit is overseeing this investigation. I believe the charges are being processed through first appearance this afternoon, and I'll have more information about what the initial, when the filing document is coming and what the initial discovery disclosure will look like from the state when I speak to Ms. Newman following first appearance today. But we have disclosed this to them because of the very issues that they were bringing to this court. We recognized there was potentially an impact on their trial strategy and their need to discover further evidence. And there was information disclosed to them in June of 2025. There have been additional developments, newly discovered evidence as of even this week that have furthered this investigation to the point where the state of Florida did issue a warrant and has served that warrant. And there could have been no way to give them this information earlier than this week just because of the nature of the investigation and the newly discovered evidence. It was not in the control of the state to discover what we needed to discover to issue this warrant until this week.
I guess I was putting it to the defense, but I need some kind of gauge. Obviously, there's been a lot of planning, preparation, sacrifice, monies placed into the next month. So do you have any idea of the time that you're requesting?
May I have a moment? We have a plan, and we've discussed it with defense in terms of timing. I will say that this lack of opposition from the state is not in a vacuum to their motion. The state also filed a motion to strike trial witnesses. I know we told Your Honor that this morning. It's been docketed this morning before 9 a.m. The defense has also, while Mr. Mizrahi and Mr. Siegel and I were in trial in the previous case the past 2 weeks, disclosed some number of new witnesses to us and some new exhibits to us, including 4 witnesses that I believe have technical and/or expert testimony to offer. Due to us being in trial, we had no ability to investigate what these people would say, set depositions. So the 2 are married, and that is part of the reason of the state's lack of opposition here. We gave them this new discovery. They have given us a large number of discovery witnesses that most likely were, at least one of them, known to defense prior to last week. We have no ability to properly prepare these witnesses while we were in trial and now seeking to pick a jury on Monday. So it's a combination of the 2. I spoke to Mr. Carodi this morning. The state's intention, if this court were to grant the defense motion to continue, would be to go before the grand jury, join Ms. Gardner and Mr. Tennant on the same indictment and seek to try them both at Mr. Tennant's already scheduled trial date and just expand the weeks that we have set aside. I believe his trial is set the last week of March, first week into April of 2027, and that is for judicial economy purposes. I understand there's been a great deal of expenditure on the part of many, many people to get us here. We've completed 1 trial. We believe that we can join these 2 defendants on 1 indictment. There are no Bruton issues, and for judicial economy's sake, conduct 1 trial simultaneously with both defendants. It would be longer than we anticipated for Mr. Tennant, but that would not necessitate 2 separate trials. That would be our suggestion. We can certainly have further conversations with defense. They were very brief and limited this morning, and have a status with the court and come back and finalize those plans. And if the court has unavailability to expand those weeks, we can discuss other alternatives. But our intention is to join them on a single indictment and try them together.
Right.
Your Honor, what we would propose also is that the parties meet and confer and propose a schedule to the court. Perhaps we could set a status for early next week. I do want to notify the court that Mr. Baez and myself are unavailable. We have another trial starting in March 2027, but I'm happy to meet with the state and we can propose a schedule to the court.
If we join them in the indictment, we'll have to obviously coordinate with Ms. Schlacks as well and her trial availability.
And you factored in that, the state's intent into your request of the court?
Yes, Your Honor.
So I know Ms. Schlacks had a death penalty case with me. And I think she had something intervening. I just know that because actually, I think I bumped another case for that case. That case resolved. You said those documents are going to be available when? In the case?
In the other case, I need to speak with Ms. Newman with our office. Mr. Fernandez is going through first appearance as we speak to get an idea from her of the timeline for the filing of charges and the disclosure of discovery. Some of that discovery relating to one of the charges was released to defense back in June 2025, a very limited amount. And I'm sure that we can facilitate release of some of this information ahead of the charging document. We issued the warrant. We arrested him. I'll get them what they need.
I'm going to be in recess. Let me see the lawyers in the side room. All right, based on my consultation with all sides, and that's also including Ms. Schlax, who represents Henry Tenen. She was kind enough to get on the phone in short notice. The unopposed motion to continue the trial date will be granted. Strike the dates that have been previously set.
Yes, Your Honor.
I'll add Mr. Tenen on with Ms. Schlax present. I'm not sure why Ms. Gardner's case was docketed twice, but the status hearing has been canceled. We're only operating on the final pretrial, so I'll grant the motion to continue. Do you think the week will be sufficient to pick a jury?
Yes, Your Honor.
And that's with both defendants potentially going at that time if the court doesn't sever them.
Yes, Your Honor, I think that would be appropriate.
All right. Working backwards. The case will be, Ms. Gardner's case is continued to May 3rd, 2027, 9 a.m. Jury selection. May 10th, 2027 will be trial week 1. May 17th, 2027 will be trial week 2. May 24th, 2027 will be trial week 3. Are you all available on October 27th for a pretrial? Okay, I'll see you all then. October 27th, 9 a.m., and that's for pretrial. Thank you. Court's adjourned.